All set.
Yes.
Yep. Ready to go.
Good evening, everyone, and welcome to this evening's Danvers Zoning Board of Appeals. We are now in session. I would ask that if you could please silence any mobile devices you have or set them to vibrate so we are not interrupted. I'm going to start by introducing our board members. Down to my right is one of our alternates, Kevin Burrich. Next to him is Corrine Doherty. Our clerk tonight, Ken Scholes, myself, John Bowner is the chair. To my left, to your stage left, is Ken Jarvinen, Chris Dembowski, and our other alternate, Becky Kilborn. Again, coming back. Thank you, Becky. And from our planning department is our planning director, Mr. Brian Zakelli. I'm going to just take a couple minutes for those who are not here on a regular basis to explain our process. Our clerk will read your case. And once that case is called, we ask that you go up to the podium if you're here to present. Tell the board what it is you'd like to do. And at that point, we will turn it back over to the zoning board for questions. After the questions period, I will open it up for public questions or comment. Again, everything through the chair, please. And at that point, we would close the public hearing portion, the public comment portion, and we will go and deliberate in front of you in an open meeting setting here. And at that point, we'll tell you what your options are based on how you hear our deliberations going and how the vote is going in your case. Board members, in this instance tonight, we don't have minutes to accept, so we're going to get right into this. We are going to jump in the agenda, and Mr. Clerk, I believe we're going to go with the 153 Andover Street to start.
Thank you, Mr. Chairman. First case is 153 Andover Street. This is Route 114A zone. Request a finding under Section 10, off-street parking standards 1 and 2, to allow for a reduction in the required parking spaces for outdoor storage. Additionally, the applicant requests a special permit under Section 30 for retail sales and display on-site that do not meet the performance standards. The request is made by Lowe's Home Centers, LLC, care of CESO, Inc., docket 26-5142.
And I will go out to our planning director, Brian, if just a quick blurb maybe here on, we're looking to continue this, correct?
Yes, in the middle of reviewing this application, we realized that although they had a proposed condition, they did not explain the existing condition as well as I'd like. So I wanted them to make a plan showing the existing and the proposed on showing what is actually changing in terms of the outdoor sales and display. They said that sounds fine. We request to continue based on your feedback. We will meet you on the 7/27 meeting.
Okay, so they've asked for the 27th. And as I mentioned, I don't believe any of the board members got any of the prior decisions at that address. So if we could just get that.
So there's about 17 decisions at that address due to it's a condo, so it's not just Lowe's. There are several other properties there, but there's only 2 that are pertinent to this, and those will be in everyone's packet.
Okay, and that'll go on the online file.
Correct.
For the 27th of July. All right, if I could get a motion to continue this to July 27th.
I make a motion to continue the application for 153 Andover Street until July 27th hearing.
Can I get a second,
I'll
please?
second.
Any further discussion? Hearing none, all in favor? Aye. Opposed? Very good. And as mentioned prior, our next case, there's actually 3 of the members here that have to recuse themselves. Myself, our clerk, Ken Scholes, and Corrine Doherty. And in our absence, Becky will chair this case of 8 Fairview Street, and Chris Dembowski will operate as clerk.
I am going to move.
Yep.
It's easier.
Brian, while we have a moment, could you just move the microphone closer? Thank you.
Oh, I don't need all that, thanks.
Okay, I know we have a number of neighbors here, and so I'm just going to repeat what John said. We're going to have a presentation of, by the person, the applicant who submitted this application. Then we will go to the board for questions of the applicant. Then after that, I will go to the audience, to anyone who's here from the neighborhood who wants to speak regarding this application, and then we'll go back to the board for deliberation. So just so you have a little bit of an idea what we're going to do. Who is here? And we need to read in the case.
Thank you, Madam Chair. Our first continued case tonight is 8 Fairview Street, located in the R3 District, map 30, lot 24. Request a variance under Section 7, Table 2, Table of Dimensional Requirements to permit the construction of a single-family home on a 10,000 square foot lot where 30,000 square feet is required. The applicant also seeks an appeal of the building commissioner's denial of permit R-26-72 related to the construction of a single-family home at this location. The request is made by 8 Fairview Street LLC, care of Jason A. Panos Esquire, docket 26-5136.
Madam Chair, if I could just
Absolutely.
ask a question of you or make a suggestion. If we could take the appeal first, depending on how that goes, it may make the variance irrelevant
Okay.
or moot. Or if you wanted to do them both at the same time, but they are somewhat separate issues with separate arguments and justifications and rationale. And I don't know if
How
the
does the
applicant has any.
applicant feel about that?
For the record, my name is Jason Panos, practicing law at 246 Andover Street, Peabody, Massachusetts. My plan tonight, through the chair, was to go through the entire presentation, hit all of the issues, and I fully expect that if you are prepared to vote tonight, that you will bifurcate the two
Okay.
requests for relief. So
Okay.
how you order that is...
You're prepared, and you can go ahead with your presentation the way you prepared it. That's
Right,
fine.
excellent.
Yes.
Are you ready?
Yes, we're ready.
Excellent, thank you. So...
Our ears are open.
Buckle your seatbelts. So again, for the record, my name is Jason Panos, practicing law at 246 Andover Street. I represent the petitioner. Good evening. The petitioner is 8 Fairview Street LLC, and they're represented by Christopher Iacoviello, pardon me, Chris, of 7 Greenleaf Drive, Danvers, and Andy Rowe at 11 Avon Street, Melrose. And as I indicated, they are here tonight. Some housekeeping issues. I sent a supplemental memorandum to planning yesterday, which got circulated with some additional support, not really changing anything we requested in the initial application, but giving you additional support for our position tonight. And I'll do the best I can to unpackage that for you, because there are a lot of facts and circumstances that that I'm going to do the best I can to clarify and synthesize and simplify to the extent they can be simplified. And really what we have here is an unfortunate set of circumstances, and it's not my goal from the outset to embarrass or criticize a process. I just want to state the set of facts that presupposed why we're here tonight, and hopefully ask for the assistance. Well, not hopefully, I will ask for the assistance of the board to kind of rectify it. To give you a little property background, the property at 8 Fairview Street predates zoning adopted on June 19th, 1946, and is comprised of lots 72, 73, 74, and 76 on an 1897 plan.
72, 73, 74, 75.
I'm sorry.
Please don't interrupt him.
Thank you. So 8 Fairview is comprised of 72, 73, 74, and 75. referenced on the plan of land from 1897. The whole neighborhood is comprised of parcels from that 1897 plan. And even today, if anyone were to convey any parcels, convey their house, sell their house to another person, the deed reference would be according to that plan, by and large. There was a plan for property across the street that combined certain parcels. That is an exception. However, that 1897 plan is the predominant plan that describes all of the lots in that, most of the lots in that neighborhood. The property is a 10,000 square foot vacant corner lot, which has frontage on both Burn Street at 100 feet and Fairview Street, also 100 feet. The property is bounded by both Burn Street to its west, Fairview Street to its south, the property at 2 Burn Street to its north, and the property at 6 Fairview Street to its east. And I've given you, by the way, that plan in the materials, if you care to follow along. The property is currently located in the town's residential 3 zoning district, which allows by right, among other things, use of the property as a single-family dwelling. And in fact, all of the houses in that neighborhood are single-family dwelling houses. The lots depicted on that 1897 plan were lawfully created when it was recorded at the registry and predate, as I indicated, the adoption of zoning in 1946. And as I indicated, that plan remains the reference plan for almost all of the lots in the neighborhood. Notably, the 1897 plan is the most recent plan of record depicting the property, and those at 2 Burn Street and 6 Fairview Street, and the property itself and the lots comprising these properties have not been reconfigured in any manner. As I indicated, if you take a look at the applicant's deed, it's by reference to those lots on that plan. The property and those at 2 Burn Street and 6 Fairview Street are legal, pre-existing, and non-conforming lots. The property and the proposed development thereon is consistent with and similar to several adjacent and surrounding lots in the neighborhood, being undersized, with most lacking compliant frontage. Again, in the R3, requiring 30,000 square feet and 150 feet of frontage. Most of the lots do not comply with that, including 8 Fairview only to the extent of the lot area, but we do have the adequate frontage. Some brief contextual background. Why are we here? In January of 2025, the prior property owners, Michael Dargan and Catherine Dargan, sought determination by the town zoning enforcement officer that the property was buildable. On January 31st, 2025, Brian Cassidy, the town's planning technician, in an email concluded that the property was a conforming lot when zoning was first adopted in 1946. Based on those facts, he indicated, and I provided you with his email, the property is a pre-existing non-conforming lot and is buildable, which conclusion and determination is confirmed by Mr. Zacchelli in a subsequent email of February 4th, 2025, and I gave you that email. On February 5th, the Dargans arranged with Mr. Zacchelli to have the assessor designation of the property changed from non-buildable to buildable, which is accomplished, and I believe is the case today. The assessor still reflects this property as buildable. Based on this determination and change in assessment status, concluding that the lot is legal, pre-existing, and non-conforming, the applicant purchases the property on November 20th, 2025, last year, several months after all of these determinations had taken place, for the sum of $325,000 using their own personal savings. On March 5th, 2026, this year, Mr. Cassidy transmits a letter based on a telephone call from an applicant, from an owner at the adjacent 6 Fairview Street, to Dargan's attorney. So Mr. Cassidy sends a letter to Dargan's attorney. Dargan's have been out of the picture for several months at this point. And basically indicated, and I provided you with that letter, that the zoning determination was suspended without any notice to the current owner and applicant. Even though the Dargans, as I indicated, did not own the property for at least 4 months. The damage was already done. They already purchased the property. They already spent the money. The zoning determination, at least through Mr. Cassidy, was reversed. But note too, the retraction came from Mr. Cassidy, who is not the zoning enforcement officer. This made its way to the building inspector, so on March 26th, 2026, and this is all based on the record as I called it together. The applicant, through Andy Rowe, again without any knowledge that the zoning determination was suspended, submits an application for a building permit to construct a single-family house on the property with the building plans that I've given you, compliant with the zoning determination, and but for lot area compliant with all of the other zoning bylaw dimensional requirements. So but for the lot area, the house proposed meets all the setbacks, it meets the frontage, it meets the height, and so forth. The building commissioner confirms this denial in his letter of March 27th, based on alleged merger of the property with that of 6 Fairview Street. And in doing so, the property is rendered worthless, really, risking the applicant's family savings used to purchase the property. And on April 24th, that's when we filed the appeal. So there were 2 requests for relief, an appeal to overturn the building commissioner's denial of the building permit, and I'll go through why we believe that's justified. And in the alternative, grant the variance application to allow for construction of a single-family dwelling house for the undersized lot at 8 Fairview Street. So the first basis for the appeal of the building commissioner's determination. Basically, the building commissioner lacks jurisdiction to deny the building permit application based on the record that we've been able to cull. Pursuant to the zoning bylaws, the zoning administrator shall have the full duty of interpretation of the zoning bylaw, and the zoning administrator's decision shall control. As I'm sure you know, this is Section 3A of the zoning bylaw. In this case, the zoning administrator, zoning enforcement officer is Mr. Zakelli, not the building commissioner or Mr. Cassidy, upon whose letter the building commissioner's denial is based. So on the outset, we believe that the building commissioner lacked jurisdiction. That's a procedural argument. More substantively, we believe that the property is exempted from the current dimensional provisions of the zoning bylaw and is legal, pre-existing, and non-conforming. The merger doctrine, as applied by the Massachusetts courts, does not exist in the zoning bylaws. It's not a legal construct that's even addressed in your zoning bylaws. And believe me, I looked. Common ownership of lots, merger, those words are not used in your zoning bylaw. They may be implied, but not used. So what is pretty clear is zoning bylaw section 3, general provisions 4, lawfully created situations which state, and I'm going to summarize, a lot, a building, a structure, a whole host of things, but I'm just going to focus on the lot because that's what we're dealing with here, or any other activity is considered to be lawfully created with respect to zoning requirements if it was in existence on June 19th, 1946, when the zoning bylaw was originally adopted, or subsequent to June 19th, and I'm quoting directly from the bylaw, it was permitted by the zoning bylaw either by right or by special permit and was in existence prior to the effective date of any amendment which rendered it nonconforming. The property is comprised of lots created by virtue of that 1897 plan, recorded with the registry, predating zoning adopted by the town in 1946, obviously, pursuant to which all lots, streets, and ways are legally laid out. The zoning bylaws exemption affords greater protections than that afforded pursuant to General Laws, Chapter 40A, Section 6, notwithstanding, Paragraph 4, rather, notwithstanding the provisions of the same section, Paragraph 5, which I'm going to talk about in a moment. Why is that important? General Laws, Section 40A, Section 6, speaks directly to merger. For single and two-family homes, you're allowed to build those, they're grandfathered, so-called, unless you have lot merger. It expressly says that in 40A, Section 6. It does not say that in your zoning bylaw. Okay? And that distinction is really important. And case law is pretty clear that towns are allowed to adopt more liberal so-called grandfathering provisions. And when they do, they're observed. So while the statute applies current zoning requirements to lots merged for zoning purposes, the zoning bylaws clearly contain no such preclusion. Accordingly, the more liberal zoning bylaw provision exempt the property from the application of the current zoning bylaw requirements. And as I indicated, it is long held that a municipal zoning code's more generous grandfather provisions can indeed trump the grandfather protections of 40A Section 6 because the municipality may, in the first instance, provide for smaller lots in certain districts or in certain prescribed circumstances. What are the prescribed circumstances here? They're pretty simple. That the property comprised of the lots created on that recorded 1897 plan is, according to the zoning bylaws, a lot lawfully created with regard to zoning in existence prior to June 19th, 1946, when the zoning bylaw was originally adopted. But then if you read on the bylaws, you'll say, but wait, there's a provision regarding non-conforming lots directly addressing potentially this situation. And that's in Section 3, General Provisions 14, non-conforming lots. Well, I read through that really carefully, several times, in fact. And that doesn't really affect the outcome. It doesn't change the conclusion I just gave you. As required by the non-conforming lots provision, and you could read it for yourself, the property, nor those at 2 Burn Street or 6 Fairview Street, were not subdivided or otherwise changed in area or shape. They were not changed. Remember, I told you that the lots referred to on that plan are the lots that exist today. When you describe them on a title deed, they're the same lots. They haven't been subdivided, they haven't been reconfigured, they haven't been mashed together, except for those 2 lots across the street, which we're not talking about tonight. That really has nothing to do with anything with regard to this matter in front of you. So they weren't subdivided or otherwise changed in area or shape. They weren't changed in area or shape so as to increase the degree of noncompliance. They weren't changed to be closer. In other words, an affirmative act to change them to be made closer in compliance, but once brought closer into compliance with the zoning bylaws, you can't go back. None of those circumstances existed as contemplated in your bylaw. The aforementioned scenarios contemplated in the bylaw, non-conforming lots requirement, require a reconfiguration of the lots in such a manner as to render the plan obsolete. In other words, that 1897 plan would have to be replaced with another plan of record that changed somehow the configuration of the lots. That didn't happen. I.e. a subsequent post-1897 recorded plan changing lot sizes, dimensions, and further subdivisions or consolidations. That didn't happen. The lots comprising the property and those at 2 Burn Street and 6 Fairview are the same as those referenced on that 1897 plan. I'm driving that home because it's an important fact. And are referred to as such through the most recent conveyances and deeds out to the applicant, which continue to refer to those plan lots to describe the land. Once again, the cited provisions contain no reference to the concept of merged lots or parcels of land subsequently placed in common ownership, unlike the provisions of General Laws, Chapter 48, Section 6, Paragraph 4, which directly, clearly, and expressly state exactly that. Merged lots do not get the grandfather protection. Your bylaws contain no such language. The property is not subject to the current dimensional lot area provisions prescribed in the zoning bylaws requiring 30,000 square feet, where 10,000 square feet is provided, because the property is a legal pre-existing non-conforming lot, allowing for the issuance of a building permit and subsequent construction of the proposed dwelling house shown on the building plans as filed and provided to you. Notwithstanding the foregoing, the proposed development, as I indicated, shown on the building plan submitted with the application is compliant with the dimensional requirements of the zoning bylaws in all other respects. There's another provision that is a little more limiting. That is a part of 48 Section 6. So remember I said, notwithstanding paragraph 5 of 48 Section 6, we have all of this analysis that talks about paragraph 4, the preceding paragraph. Well, there's a new exemption to paragraph 4, and it was just added in 2024 under the Affordable Homes Act. And this I will read to you because it's fairly straightforward and short. That adjacent lots under common ownership shall not be treated as a single lot for local zoning purposes if at the time of recording or endorsement, that's the operative time, the lots conformed to then existing requirements of area, frontage, width, yard, or depth, where each such lot has not less than 10,000 square feet of area and 75 feet of frontage, and are located in a zoning district that allows for single-family residential use. Here's the catch. Any single-family residential structure constructed on said lot shall not exceed 1,850 square feet of heated livable area. That excludes attics, it excludes basements if they're not heated, not finishable garages. I have clients who even count exterior wall clapboarding and get 50 to 75 square feet out of that when they do their deductions. So an 1,850 square foot heated livable area house would translate probably to a 2,400 square foot house by the end of the day, within a footprint. Has to contain no less than 3 bedrooms and shall not be used as a seasonal home or short-term rental. I don't want to concede my argument in the first instance of why your bylaws allow this particular property to be pre-existing and non-conforming, but this is an option for you to consider as you go through all of this. This newly added statutory provision expressly overrides the common law doctrine of merger as applied by the building commissioner and as interpreted by the Massachusetts courts, and applies to the property. Specifically, the provision was enacted to and expressly precludes merger of lots alleged to have occurred between 8 Fairview Street and 6 Fairview Street, resulting in the building commissioner's denial of the applicant's building permit application. Here, the operative time frame, as I indicated, as a measure of compliance with the zoning status, is clearly the time of plan recording and endorsement. The property is comprised of plan lots created in 1897, predating the adoption of 1946 zoning. And it is, by virtue of that, compliant with the then applicable zoning requirements at the time of recording. You didn't have zoning in 1897. The lots were created in 1897. They were compliant with zoning. That's basically the conclusion. The property meets and exceeds all of the criteria established in the new statute. It's 10,000 square feet. It has 200 lineal feet of frontage, where 75 feet is required. The property is located in the R3 district, which expressly allows for a single-family residential use. The property clearly and expressly complies with both the spirit and intent of 40A, Section 6, Paragraph 5, allowing for construction there of a residential 3-bedroom dwelling house of no greater than 1,850 square feet of heated livable space, and precludes use of that home as a seasonal home or a short-term rental. So in this case, there was lot merger. It happened before 1946. You have 4 lots that combined into one to create 10,000 square feet. And now with the addition of this provision, this new statute from 2024, it steps in to prevent that lot from being denied constructability. Does that make sense?
Yeah.
Okay. So that is the application of the 3 factors we believe justify the overturning of the building commissioner's denial of the building permit. So jurisdiction, process, he didn't have jurisdiction. He overturned it based on not the zoning enforcement officer's determination, but one made by someone in planning. But more substantively, your own zoning bylaws would support the notion that this is a legal pre-existing non-conforming lot. And on top of that, the new provision of 40A Section 6 would prevent merger from occurring, that would prevent the construction of a house there for 1,850 livable square feet, 3 bedrooms, with the restrictions that I discussed. Alternatively, we believe variance factors are met and hardship justifies the grant of a variance, if you want to go there. The topography of the property justifies the issuance of the requested variance. Specifically, there's a 13-foot grade change from the easterly bound of the property at 6 Fairview Street to the southwesterly bound at Burn Street. This grade change results in a limited area pursuant to which the property can be developed and is specific to that property and does not generally affect the zoning district in which it is located. Additionally, the lot area of the property is deficient in accordance with the zoning bylaw resulting from the various conveyances. So I give you in the most recent memo a rundown of how these lots came to be. And the fellow's name who did this is David Blair and his wife Emma. So Blair bought up all these lots through a period of, 20 years or so, and he played Tetris with the lots. He bought them, sold some off, kept some, the house at
Probably
6...
don't need all that history.
Yeah, exactly, but you have it. You
Okay.
have it in front of
Thank
you
you.
if you want it. So all of that basically resulted in the size and shape of the lots as they are today. So the lot behind us, for example, at 2 Burns, is 10,000 square feet. It's almost the same exact lot as ours, except it has less frontage.
Yeah.
And that too, applying the arguments, would have been non-buildable because the zoning changed by the time that house was built in 1960. Zoning changed in 1957. I'm now an expert on the history of Danvers zoning. Changed in 1957 from 8,000 square feet, which was required in that zone, residential, agricultural residential rather, to 18,000 square feet. So that too, they're all pre-existing. The point is non-conforming. And so the lot shape as a function of the lot area as a function of lot shape is deficient, not through anything these guys did, but occurred decades ago, resulting in a literal enforcement of the provisions of the zoning bylaws requiring 30,000 square feet with 10,000 square feet are provided, involving a substantial hardship, financial or otherwise, to the petitioner, especially where the proposed development of the property complies in all other respects to the dimensional zoning bylaws and requirements. So a variance can be granted because it fits within the neighborhood. It's the same exact thing as what's around us. To the public good because proposed development at the property is consistent with other dwelling houses in the neighborhood. Also consistent with zoning bylaw section 1.1 purpose, which prescribes the many zoning bylaws purposes, being one of them being the careful development of land in town. Putting the property to a developable use consistent with that proposed by the applicant is more desirable than leaving it vacant because it will provide for increased housing stock and result in higher tax revenues to the town. There is, as I indicated, no self-imposed hardship because topographical and lot-shaped circumstances pursuant to which the property pre-exists the applicant's ownership of it. The applicant had nothing to do with the topography or the lot size, lot area. The property became non-conforming to the requirements of the zoning bylaws well before the applicant's ownership, when dating back to as early as 1942. Title resulted in conveyances resulting in the deficient lot area. So this brings us back to why we're here. We're asking you to overturn the building commissioner's denial of the applicant's building permit, or in the alternative, grant the variance, allowing for the proposed development on the property, providing 10,000 square feet where 30,000 square feet are required. So with that, I'm happy to entertain, I know that's a lot, and I
It's a
tried
lot.
to...
And a lot that we've reviewed prior to this meeting, so,
I'm sorry?
and a lot of information that we've reviewed prior to this meeting.
good.
So, yes.
So if you have any
So
questions...
what we would like to do is ask you some questions.
Yes.
And we'll go through that. And then we'll go to the audience for any comments or questions from them, and then we'll deliberate.
Okay, sure.
So I'm going to start with you, Kevin, if you would like.
Sure. Mr. Panos, thank you for the lengthy but thorough presentation. I want to maybe just ask about a couple of issues. So your, first of all, your first memo accompanying the appeal, I think made some additional arguments, more about timeliness, and essentially saying that the letters from town staff constituted an appealable decision. Those decisions were not appealed within 30 days. I haven't heard you repeat those arguments tonight. I was wondering if you were kind of, in essence, abandoning those arguments or just didn't make the summary.
It didn't make the summary because it's in the papers, and you've had that for several weeks now. But I'm glad you raised it. It's a jurisdictional issue. And the fact is that under 40A Section 15, if the zoning enforcement officer issues a determination that causes aggrievement to someone else, that someone else has the right and ability to appeal that determination to you. Now, and they have to do so within 30 days. Now, I understand that the determination came through this course of emails that happened back in January. And I understand that some people wouldn't have picked up on that to figure out whether or not it would have caused aggrievement. But come March, early March, let's say March 1st, maybe end of February, because Mr. Cassidy's letter is March 5th. So sometime before March 5th, someone certainly caught wind from 6 Fairview, called and said, but there was lot merger between 6 and 8. You can't render this determination because merger precludes a determination that would have allowed those lots to be buildable. No, you don't do it that way. You don't drop a dime and give someone a deed and say, reverse your determination. No. When you find out about the determination, you appeal it. You appeal it so that this board can afford the same open hearing process that we're going through right now to determine the facts. That didn't happen.
So I think I understand the argument. I guess taking...
And I'm not waiving it, no.
No, okay. But taking it to its next, the next point in that argument,
Yes.
Certainly staff can issue advisory opinions that don't count as an appealable final decision, no?
The rule of law, the rule basically is if there is a decision, a determination that causes aggrievement to someone else, it is appealable by definition. You look at, and aggrievement is in the eye of the beholder, but, and I'll make this as simple and succinct as possible. The courts, legislature, everybody wants housing. It's to address a housing crisis. So they've made it a heck of a lot harder to mount these cases of proving aggrievement. You have to now show particularized harm. Even before this board, appeals of building permits, appeals of zoning determinations, you have to show how you are specifically harmed by that determination. However, and there's no presumption of aggrievement. There's no immediate presumption of harm like there used to be. And these are changes that are recent, okay? But the fact is, if you feel you are aggrieved, you are somehow harmed by a determination of the zoning enforcement officer, it's your responsibility to exercise and exhaust your administrative remedies, an appeal to the Zoning Board of Appeals, before you bring this to court. And if you don't, there's an argument that you're not even allowed to appeal the building permit because you sat on your rights at a time you realized you had them. So does the 30-day time clock start at the time the determination was made back in February of last year? Probably not. How can you know? If you didn't know about it, you didn't know about it.
Right.
But certainly when you did, you start counting the days. And that time is long gone.
So since you brought up Section 15 of 40A.
Yes.
So
That's going off my memory.
So, good memory. I think you're exactly correct about the right section. So, I guess for the appeal portion, in your initial
Yep.
letter, you essentially brought up the procedural issues.
Sure.
And then yesterday, sent a supplement to the town.
Yes.
In which you brought up new substantive issues that had to
Yes.
do with your analysis of the law, your analysis of the history of whatever hill it is that was on the plan.
Cedar Hill.
Cedar Hill, the history of Cedar Hill.
1897.
So I guess, given that the responsibility of the applicant when you're appealing is to state within 30 days, appeal and state the grounds, I'm concerned that these new substantive arguments, although I find them more compelling than the procedural ones, I'm concerned that are you time limited here, and that you stated new grounds after 30 days rather than expanding upon the initial grounds that you raised?
No, I was very careful in my supplemental memo to make sure that the initial analysis remained intact, and this was only in addition to that. No, I'm not precluded from making those arguments because, look, I know how thorny process can be, and the board deserved more.
Okay.
And so I gave you more, and I gave you 3 legal bases. The variance was always there, that was in the initial papers, but when I looked at the property, I mean, the property topography didn't change in 2 weeks. And I said, we have a topography issue, so that's a variance. I looked at the zoning bylaw again, and I started looking at the case law just to give you an idea of my kind of process. I looked at the case law, I said, wait a minute, their zoning bylaw, section 3, paragraph 4, is quite a bit more liberal than what 48 section 6 affords. And so I wanted to make you aware of that, to the extent you're not.
Do you happen to have the citation that you're thinking of
For what?
on that? For the more liberal grandfathering of a...
It's in your zoning bylaw.
But I think you said that there is some case law on this that
I
that
cited
the
it.
more liberal zoning bylaw will control over.
It's the Marinelli case, and
Thank
I
you.
cite to it in my papers.
Thank you.
Yes. It's the only case. I was a chair of a zoning board of appeals for 10 years in neighboring Peabody. So, and I'm a lawyer, and I should eat all of this stuff up. Well, I don't. The simpler I can keep it, the better. We're not in court.
And I think this is my last one. So
Yeah.
if we found none of the arguments that I've been asking questions about, to be prevailing, but the merger doctrine kind of exception that was written in 2024, 1,850 square feet.
Yep.
I guess, what was the square footage of the house that you proposed building? And can you get to 1850 if you subtract exterior walls and things like that, like you were suggesting?
It's a great question, and I addressed that in a footnote in my memo. So that's a discussion that should happen between the applicant and the building inspector. And so the plans presented, the building plans, show in excess of 1,850 square feet of livable area. But I don't think it went through the calculation. It had a deduction for a couple of things, but certainly not a comprehensive list of deductions. So I think the basement area in those building plans might have been included in the livable area, that type of thing. Certainly, back to the drawing board. Let's do some deductions and allow that process to flesh out. Can they be tapered down? I'm sure they can be.
Yeah, I think, obviously, I'll ask this now because I won't be able to ask you a question during the deliberation portion, right? So,
Yes.
I find that to be the most compelling argument for the exception, for the appeal, right, portion. So, I guess if I were to vote in favor of granting the appeal, it would be because of that, right? But unfortunately, if I vote in favor of granting the appeal, I'm just voting to overturn, right? Without,
Correct.
and grant it without that calculation of the 1,850 square feet. So
Correct.
Can you help me square that circle?
Yes, absolutely. Well, just turn the circle into a square. Pardon me. Yes, again, that's a conversation that happens between the building inspector and the applicant. So I would fully expect that they would go back with another revised set of plans and say, okay, that chart that was on our building plans that showed 23, 24, whatever, 100 livable area, well, it's not really that because now the attic is no longer heated. For example, the building plans are provided to you, or the basement is restricted, it's not heated, or we didn't take out a utility area that's 500 square feet, something like that. So, yes, that's exactly right.
Can go back to him with.
Okay.
Right.
Yeah, with-
And your determination tonight would simply be, no, building commissioner, we don't agree with you. We're sending these people back to talk with you about a building permit for this.
Okay.
You know,
And,
yeah.
and those conditions that kind of come with that exception, right? It can't be a short-term rental, it can't be an
Correct.
Airbnb, it can't be a seasonal residence. How do those conditions stay in effect for perpetuity? Do those have to get conveyed in the deeds?
That's a great question, and yes, I believe, I just did 20 lots in Ashland on this very basis. And we're figuring this out right now because we are at the point where we're doing a full subdivision. And we're in the process of building the streets and the ways and the stormwater management system, and we'll be conveying out the lots pretty soon. And we believe that either there'll be some reference to 40A, Section 6, Paragraph 5 in the deed, 5 in the deed, something like that, but we haven't quite figured it out. I mean, as a matter of law, the restriction is there. And it's all over our plans, by the way. We recorded plans at the Registry of Deeds. 40A, Section 6 is all over the place on those plans. So I'm not sure how we'll do it, but we'd be happy to have fashioned some kind of condition in that regard if that's where the board ended up.
Madam Chair, thank you for your patience with my large number of questions,
No,
but that
that's
is.
fine.
that
I hope I
concludes
answered them adequately.
Thank you, sir.
Thank you.
Thank you.
Okay, you're up.
All right. So I'm just wondering, why wasn't this caught during title search? And when the purchase of the property with the closing attorney and the title search, it seems like
It's a good question.
there's a lot of deeds going back, way back to the 1800s and stuff.
Yeah.
You would think a structured, pragmatic title search would have revealed some of the issues here.
So the title standard for title search is 50 years. They went back to 1966
50
when
years.
all of this happened. After all of this happened. So you're 100% right. That this particular discrete set of issues and circumstances, which were not contemplated at the time of the property conveyance or the property purchase, because the property was purchased on the basis of a determination that this was a buildable lot. So none of that was really in consideration. And let's face it, it's a 10,000 square foot lot. You shouldn't have to hire, if you have a determination on record, you have an assessment change from not buildable to buildable, you shouldn't have to hire an attorney to look at this more carefully. You should be able to rely on it, on its face. That is what happened here.
Well,
So there was that title search that went back 50 years and didn't catch any of that. So that's why.
so in 1966, was it conclusive that this was a buildable lot?
It wasn't even a consideration. All they were looking at was title. What happened? When was this acquired? What was the first deed out? Going back 50 years. And do we get to our conveyance for value. In other words, are they interrelated deeds, among family members for zero consideration, for all the love and health in the world, or are they real deeds, right? Are they deeds for actual consideration? So they go back 50 years. If 50 years isn't the benchmark, then they go back beyond 50 years. Here, they didn't have to go back beyond 1966. That was their benchmark for this property. But they weren't looking at a zoning issue. They were looking at title. So they met the title standard. I wasn't involved in the purchase, by the way, or the acquisition.
Well, so the
But they met the
intent,
title standard.
the intent of the purchase was to build on it.
Correct.
So based on getting the loan from the bank and the bank
There was no
attorney-
loan. This was their personal family money.
Well, the closing attorney,
Yeah.
I mean, probably had some sort of inkling that there was going to be building on this lot.
He did?
He didn't.
Well, he didn't need to because there wasn't a mortgage. It was just a deed of conveyance.
So then no one was looking out for the best interests of.
Correct.
In
The
this-
seller's attorney, however, had a heavy hand in this. The seller's attorney is the one who got and the seller himself, they were the ones who got the determinations from the town. Keep in mind, all of that happened in February. The closing didn't happen until November. So between that period of time, everybody thought we had a buildable lot based on the determinations that were rendered by the town, by the zoning
Well,
enforcement
no,
officer and town
fairness,
planning.
there isn't title searches and closing and property attorneys
Right.
in the planning office.
Sure.
I mean, so Mr. Zakelli and Mr. Cassidy were doing the best they could with what they had knowledge
Sure.
of. And then they found a mistake, or they found an issue, and then they brought it forth. So, I mean, they try to fix it. I mean, the timing wasn't the best, but all of it shouldn't be on them because it seems like something's lacking, some due diligence or something with the not the title search per se, but the other piece of the pie, whether it was
Do you have
Right.
questions?
buildable.
Questions?
Well, I'm just sort of hung up on that, like,
Okay.
how did this get missed? Because it seems like there's something
It's
missing
a good question.
here.
He wasn't
And-
involved in this.
And I wasn't involved, but I'm not going to duck the question. Number one, it got missed by the closing attorneys because they weren't looking at it and they met their title standard, for conveyances. Number two, there was a significant amount of back and forth, and I gave it to you, in emails between the seller and the seller's attorney and the town. Now, if the town, and again, I don't want to embarrass anybody. I'm not here to do that. But if there was a question, and there clearly was, a lot of these issues were vetted out. If you look at the correspondence I provided you, if there was a question, then the determination should never have been made.
I don't,
You-
it doesn't
you
sound
two
like it
should
was
have-
concrete. When I read it, it
Yeah.
seems very superficial. It doesn't seem like a deep dive, like, it doesn't seem a lot's going on there. It seems like it was.
You're talking about the background and the
No, I'm talking
memo
about
from
the
the seller's
emails
attorney.
themselves.
Right.
They don't seem deep enough to warrant like a real study. It seems like they're just going about, this is what usually happens in these circumstances without all the information, that they didn't have all the information. And then once they found out that information, that's just at first blush when I read that.
Yeah,
I just see that there seems like there's something that they didn't know.
If
and
you
they-
look at it more carefully, there were some pretty strong conclusions drawn in those emails, to the point where the assessment designation was changed. So, and not only was the conclusion drawn in the email, it was reiterated. There was an email issued on January 31st from Mr. Cassidy, which was confirmed on February 4th, 2025. And I'm going to read it to you. Dear Mr. Dargan, this is from Brian Cassidy. Dear Mr. Dargan, sorry for the confusion. So they had been going back and forth on this quite a bit, okay? Brian Zakelli and I reviewed the facts today and agree that as stated in my January 31st, 2025 email to you, number one, we do not believe parcel 1 and parcel 2, parcel 1 was a parcel across the street. I'm not sure why that was ever in consideration, just to give you context. And parcel 2 is 8 Fairview Street. Parcel 1 and parcel 2 ever merged. Since 1887, the lots, 1897 really, the lots were separated, oh, well, perhaps 1887. I'm sorry, I'm going to keep reading and not interrupt myself. Since 1887, the lots were separated by Fairview Street. See attached plan. The parcel 2 has 100 feet of frontage on Fairview Street and 100 feet of frontage on Burn Street and contains 10,000 square feet of land. And number 3, parcel 2 was a conforming lot when zoning was first adopted in 1946. Minimum 8,000 square feet on 80 feet of frontage. Based on those facts, parcel 2 is a pre-existing, non-conforming, and buildable lot. He states this conclusion. It's not a casual statement. This is pretty definitive. He looked at this. He
Why-
discussed it.
I meant on the emails, but then there was after this, after there was other information that they.
There was a
must have-
memo that was drafted by the Dargan's attorney back in November 5th of 2025. This was before the closing. And I provided this to you. And he lays out his argument for why, and I'm not sure why this memo came into play after that very definitive conclusion was drawn. But there was a memo drafted November 5th, 2025 that provided some of the background that you're alluding to. That's one rather large paragraph, 2 paragraphs really, and talks about what happened and why the lot is pre-existing non-conforming. Look, I'm not sure I agree with the analysis in that November 5th letter, and I've given you other bases other than what's in that letter. But the fact of the matter is there was a significant amount of back and forth that led to a concrete determination, to your question. It wasn't just a casual conclusion. It was a concrete conclusion based on a lot of back and forth. And if there was any trepidation, if there was any hesitation upstairs, the determination should never have been made, and you should have said, you know what, we should have town council look at this. That I don't think ever happened. But the conclusion was made. And so these guys came along and said, we've got a determination, and I believe these guys even personally engaged with the counter to make sure. They didn't hire an attorney, that is correct, to look at this discrete issue. They relied on the written record.
So why does this say unofficial property report card, record card?
That's your record card
So it's
from the town
unofficial?
records.
It's just printed off the page. That's just what it's just
Okay,
called.
I
Yeah,
thought,
yeah.
all right, I didn't know if it was,
Yeah, that's your record card
all right.
that everybody has access to.
Yeah, I'm all set. I just, yeah, I thought it just wasn't thoroughly handled beforehand, but I'm done.
All right. Well, thank you for your question.
Chris? Where do you go?
Was there ever a plot plan done on this plot showing what they want to do with this house on this plot?
I believe it was provided at the time of the
The building permit.
building permit. However, I did provide you, let's take a look at the date of the existing, no, there was, yeah, see the big plan?
There's an actual plan.
Yeah, yeah.
I'm trying to avoid opening that.
It shows a setback compliant house.
Okay, so that answers my question.
Yeah.
Yeah, and it's dated February 20th, 2026. So it happened, this plot plan was done after, it was in preparation for the building permit.
So I think
And there
I'm,
was probably a plot plan done for the closing, because there was title, I do know there was title insurance purchase. I didn't mean to interrupt, but.
no, that's fine, but I was just looking to make sure there was a plot plan given to the building inspector.
Oh,
that
yes.
he actually physically saw before he denied anything.
Yes.
Okay.
Yeah, it would have been the
I
blow-up.
think I'm going to piggyback off Ken's question.
Yes.
Is why was there not ever deed research done on this?
Well, there was, in conjunction with the closing.
Okay, and that being said, this would have come forth that this was a 10,000 square foot lot, and we would have determined all this beforehand, correct?
Determined what exactly?
That it wasn't buildable with what they
Well, I'm
wanted.
not coming to that conclusion. I believe it is buildable, and I would have had a difference of opinion had I been involved with the building inspector at the time. I believe it is buildable. I don't believe there's a merger issue. There's not a merger issue because your bylaws say there isn't a merger issue. There's not a merger issue because 48 Section 6, Paragraph 5 says there isn't a merger issue. Merger is precluded by the express language of your own bylaw. And if you don't like that answer, it's definitely precluded, in my opinion, by the express new provision of the Affordable Homes Act. That's the whole point of the Affordable Homes Act, is merger for local zoning purposes does not preclude construction of a single-family house. So I disagree, and I'm sorry, Mr. Jarvin, was that the premise of your question as well, that we should have caught that this wasn't a buildable lot?
No, it's just all the back and forth from.
Yes, I got it.
I mean, it just seems like this should have been ferreted out before it was purchased by the next
I got it.
buyers.
And had it been ferreted out, by me anyways, I would have drawn this conclusion that I've presented to you today. So I do not agree that this is not a buildable lot.
I'm good. The rest of mine are more comments than questions, so
All right.
I'll hold off.
Okay. And the only question that I have, I think most of my questions have been answered, is going back in the records, there was a letter from Dave Harris, who was the assistant building inspector in 2016,
Okay.
saying the lot was not buildable. And I know you weren't involved in the closing. I wonder if that came up in your review of the documents.
I did not see that letter.
Okay.
But in 2016, I jumped ahead, put the cart ahead of the horse. I'm not sure how big of an expert I am on your zoning history. I'm not sure when that bylaw provision came into play.
Okay.
That grandfathering provision that I was alluding to, but certainly the Affordable Homes Act wasn't in play in 2016. So, there was a point in
Back in 2016,
time.
the building inspector made the zoning decisions,
Sure.
so it's
Sure.
changed since then. So that's a difference in the way that we handle this.
Right.
But
But I'm
there's a lot
unfamiliar
of,
with
I
that.
went through all the different emails, and there's a lot of back and forth. It's not buildable, it's buildable, it's not buildable, it's
Yes.
buildable. So, I wondered how much you looked into that.
I did not see that 2016 letter.
Okay,
But what I did was undertake the exhaustive title work that Mr. Jarvin indicated. Took me there are tricks on the Registry of Deeds website where you can find this stuff that goes back to 1887, and 1897, and I tracked forward basically a lot of these deeds. A lot of it, a lot of the information was a lot of background information that really isn't valuable here.
Okay.
So,
If you're pretty
Yeah.
good.
Yes, I
I'd
am.
like to go to the audience.
Yes.
If that's, unless you have anything else you'd like to share
I
with
don't.
us.
I hope I
We may
ans-
have some back and forth once we deliberate.
Sure.
But,
I'm happy to. I'll wait until the deliberation, but my understanding is that there'll be an opportunity to understand where
I
where
mean,
the
we won't
board's
be asking
collective.
you any more questions, but I think that I have some of the same issues you do.
Yeah, but I think,
yeah.
I think, Madam
I
Chair,
think we're pretty good,
to
right?
address Mr. Panos' question, like, we normally give the applicant some options.
Yes.
Before we vote.
So,
Yeah.
so we may call you back for that. Okay? All right. So we now have the audience. Sir, would you like to please give us your name and your address?
I would love to. Good evening, everybody. My name is William Costawan, and I own 7 Fairview Street. I am what you call a townie. I have been familiar with Cedar Hill since the mid-1960s. I'm the last living beneficiary of that family neighborhood.
Okay.
And boy, what a performance. This was star performance. I haven't been this insulted as a Danvers resident, I think,
Let's
ever.
be kind.
I am being kind, madam, but let me get into my notes here. All right, I became aware of what was going on with the property on December 26th, 2025, when I happened to see a land surveyor outside my
After
window.
it closed.
After it closed.
Okay.
Okay? Such point, I happened to mention it to Mrs. Smith over here. The following business day, I was down here in Town Hall, and I began my investigation, asking various questions of various personalities. So I'm going to use some very simple language here and tell you what my perception of this is, all right? So going forward here, the focal point here of this meeting is denial of permit R2672. And regarding this, we shouldn't be having this conversation, as in the perfect world, this would have been dead on arrival, okay? The sale of 8 Fairview Street was perceived to have proceeded under a cloak of subterfuge, complicated by incompetence and/or unprofessionalism, with a conspiracy being a reasonable opinion thereof. It was like mystery. We had no idea what was going on. In my opinion, it is a blatant example of criminal-like greed and naked deceit, really. The actions of a flipper, a property developer, whatever you want to call it. The seller of the property, Mr. Doggett, although previously informed of the property's history, and that being there was transferred ownership from 6 Fairview to 9 Fairview in 1961 between family members, ergo deeming the property unbuildable. You know, he mentioned Mr. Grace and Mr. Blair. I knew these people. That was Uncle Dave. That was Uncle Bucky. That was Aunt Catherine. I knew these people, and these were straightforward people, and it was handled basically to accommodate the needs of the family. Okay, and now it's turned into splitting of hairs here. Anyway, the buyer proceeded in a questionable and unethical manner by not taking the steps necessary to verify the status. And this, to me, well, I'm not going to use a hard word, but it ain't a nice one, okay? In any event, nonetheless, the seller proceeded with the sale of his property under the cloak of secrecy, the perception being the seller assumed that if none of the parties concerned became aware of the sale, no one could or no would challenge the legality of the sale, nor be able to stop development of the property. I believe that is exactly what the case is here, all right?
Well, I'm just going to interrupt you a little bit and say that it's not the responsibility of the property owner to notify the whole neighborhood if they're going to sell their property.
Understood.
Yeah.
Point taken.
Let's-
Thank you.
yeah.
All right. To add to the mix of this highly unprofessional situation, is both curious and suspicious the town of Danvers lacked the detailed provenance of this property prior to 1966. I mean, how is that? How is the town of Danvers, shall we say, in the dark on something like that? But I'll just mention that. Continuing on, a thing that really, I think, floored me here, in continuing, almost unbelievable, the situation was further complicated by both the seller's and the buyer's legal representation. Somehow, both during discovery, coincidentally overlooked this property's history prior to 1966. And by doing such, created the impression that they too thought no one could nor would challenge the legality of this transaction. Thereby, by their actions or lack thereof, they became accessories to this scenario, as far as I'm concerned. Once the sale came to light, which came about almost by accident, like I said, December 26th, I look out my window in the middle of snow on the ground, so and so, but I'm seeing a surveyor out there, kind of odd. It was highly suspicious manner. Pertinent information regarding this property's history was then provided to the Town of Danvers Building Inspector on March 4, 2026. And upon review of the building inspector's the building inspector's office reacted by issuing the denial of permit R-2672, and the property was unbuildable, and this ruling was vetted by the town's council. And that was told to me by people who work in this building when I was inquiring about it, okay? To continue, now with the details in full view, the buyer's legal representation has the audacity to stand before this board requesting reversal or denial of permit R-2672, presenting an argument that somehow the taxpayers of Danvers should allow an appointed representation to succumb to this attempt at fraudulent travesty. And that's how I see this. This is fraud. And to reward underhandedness with a blessing of legitimacy, what an insult. I feel absolutely insulted. This man came here tonight, insulted us, our community,
Let's be
insulted
kind.
you.
Excuse me.
Let me continue, please. I'm almost done. I won't go off the rails
You won't be
anymore.
able to continue if you.
All right. All right. Now, we, the affected and aggrieved residents of Fairview, Burns, and Longfellow Streets neighborhood, stand before the Town of Danvers Zoning Board of Appeals seeking an appropriate binding decision, and that being, in view of the undeniable facts, that the denial of permit R-2672 be upheld, period.
Okay, thank you. Is there anyone else who would like to speak?
Yes, Linda Collins Smith, 6 Fairview Street.
6
Can you hear
Fairview.
me okay? Yes.
Okay.
It was the site of the original property there, and I think I can shed an awful lot of light, because when we bought the property in 1990, the Realtor brought us to a property that had an unbuildable lot, so we could see the river, the sunsets. My husband liked that he could walk to the Danvers Canoe Launch. It was, in fact, an unbuildable lot for 60 years, but just to make sure, I ended up doing the complete, not online, the old way, the complete title search. And I also checked all your zoning laws, including the grandfather. This was never an orphan lot. It was part of 6 Fairview. And I have an advantage in that one of the oldest members of the neighborhood, he was born in 1903. And I used to look in on him, and he told me the whole history, so I will try to give you a brief history of the area. So it goes back to, he's right, that 18, but it wasn't sold until 1926, and it was not the Blairs, it was Mr. Mackenzie. They were family members that all had roots in Nova Scotia.
Okay,
but
I
they live in the
think
greater
this is
Boston
going to be
area.
more information than we need.
Okay, well, I'll try to go on. So he buys 1996. He buys 12 of, it was gridded. There were 25-foot by 100-foot grids. He bought a dozen of them. It includes the property that we're talking about, so
Right.
it's sort of like L-shaped. 1946, your zoning comes in. It's all zoned. And now Blair is the owner. Jump ahead 20 more years, so 20 years it was under zoning. Again, never an orphan lot, not grandfathered, because you use the term affixed, and it was affixed to 6 Fairview Street. But what happened is these were all summer cottages. So they're starting to winterize, they're moving in here, and 9 Fairview Street, Mr. Grace, I'll call him Grandpa Grace, has a single-car driveway and basically no front lawn. He asks his relatives, the Blairs, if he can buy the property across the street from him. It sits on Burn Street, but it is across the street. That's 1967, February, is when that property is sold. And it is never sold again as a separate property. It is bundled as an unbuildable bonus lot as 9 is sold. 9 is sold 3 more successive times. 9 is sold, the last time it was bundled, was sold in 2021, is when it's sold is to, I'll call him Mike the Flipper. Comes in, and he has no endearment to the neighborhood. He tells us right up front, he tells Bill, my wife and I buy properties, and then we sell them really quickly. Mike and Bill says, this is not a $1 million neighborhood. And I say, well, apparently you're wrong, Bill, because he sold 9 Fairview Street for $1,025,000 just a year ago. And I see him taking down the sign, and I say, and did you give him the lot, Mike? Because all along I was telling him, you know, that used to be part of my land. It was adjoined, and it is not a buildable lot. And he looks away, and he says, no. He basically took their front lawn from them, because they have no front lawn. There's no place to park cars. They were sardined all winter.
That's a separate.
Okay, so ends up, the next thing I know is it's showing up online, because now I know. Most of the neighbors, by the way, did not know that it hadn't gone with the property, including Bill. But I know, and so Patriot Properties starts showing it for sale, $350,000, but unbuildable, and then overnight, almost, buildable sold. And yes, I am the one who picked up the phone, and I met the developers. They came to
We're
my
aware of
home, and they
that.
asked me, and I said, yes, I'm guilty as charged. But I just want to say that it is, how it was presented, to me, was flawed. Because I kept saying it's not a buildable lot, and they did only go back to 1960.
So the realtors or the people that were involved in the sale, you don't feel that they gave you a full story?
Are you talking about the flippers?
I guess.
the new
I don't
developers?
know. I mean, you're saying that you didn't get the full story.
Well, I don't think they gave the full story to you, to the town. I think they presented a flawed presentation. They didn't go back far enough, and I kept telling them that it is. Immediately, when you went from unbuildable to buildable, I lost one of the rights to my property. The right to quiet enjoyment
Yes.
was unconstitutionally taken because we had that, when we bought it, predicated on the
But
fact that
you don't own
60
that
years.
property, right?
We do not own, but the town always honored it, and one of the neighbors that did own, the grandson of Grandpa Grace, at one point asked the town about building. They said, that might be what you're referring to.
Yeah.
He was told point blank, no, that is not buildable, so that's what I have to go with. So I
Okay.
just want to end with this, is that at least we're here tonight discussing it.
Yes.
Because my biggest fear, as much as this has been a nightmare, was that the entire neighborhood would have woken up to backhoes, bulldozers, and cement trucks on a 14-foot street. Most of the people have never been in this neighborhood, and I
We
asked
drove up
everyone.
there, we all saw it.
Oh, okay,
Yeah.
thank you for doing that, because we had a lot of flippers who've never been on that street. That they would wake up to that digging for a 10,000 square foot lot that sits at the base of the hill, where you're gonna have storm drain, you're gonna run all kinds of things, and you're only 400 feet from one of the most endangered rivers in the country.
Yeah. Well, we
And the turtles
appreciate
like
your
to come up to
comments.
my yard,
Thank
so-
you. Thank you.
Thank you.
Yes. Go, yes. It's your turn.
Keith Richard. I'm at 1 Longfellow Street.
Okay.
Longfellow intersects Fairview.
Can you show where that is?
Can he?
There we go.
Right,
Okay.
so I abut Mrs. Smith, who abuts
One in
the lot.
between, a lot in
Yeah, right,
between. Okay.
Yeah, thank you.
And how long have you lived there?
Since 2020.
2020?
Yes.
Okay.
Yeah, thank you. So I don't have the history of some people. I appreciate the comments of my neighbors. I'm speaking, for myself here. Sticking to matters of law, I understand we separated the board separated at the beginning, the buildable lot question versus the permit denial. Can I speak to all of it?
There are two applications,
Yeah.
two specific applications.
Sure. I'll try to speak to all of it and
Okay.
allow you to sift through, which things apply where. Right. Is that good?
Yes.
Thank you. So I'm less immediately focused on the conforming size of the lot. It is worth saying it's not a 30,000 square foot lot according to R3 zoning. It's not even a 20,000 square foot lot that would satisfy R2 zoning. It barely meets what would otherwise satisfy R1 zoning. But as councils point out, the AAHA law has bearing here. My understanding, and I leave it to council and the town and the board to adjudicate this and figure this out. I don't think that the AHA supersedes other zoning bylaws, like height requirements, setback requirements, and what have you. The lot size and the frontage are, as council said, 10,000 square feet and 75 feet respectively, are sufficient for that. Some concerns we have as residents, and I do, are that there are only two ways into that neighborhood. Burns Street is one of them, Longfellow is the other. Longfellow Street becomes impassable in winter weather. We often have to resort to using Burns Street, even though it's more convenient for me to drive up Longfellow Street. Many of us get stuck, right? And we have to back down and go the other way because the whole neighborhood is raised on a hill. Though they are very narrow streets, even Burns Street can be a little tricky sometimes. But if you bite down and bear it, you can kind of get up in a car. I'm concerned about whether it meets the conditions for a permit approval or will require conditions on any approval. I think the amount of impervious surface I would expect to see for a minimum 3-bedroom house on such a small lot that is situated on a grade would exacerbate the runoff issues that we have on Burns Street. So the only other way into the neighborhood that's passable, Burns Street, I think the character of that and its ability to be passed in winter weather would change. And I would leave it to the board and the town to figure out what the redress is. Is that a denial of permit? Is that a condition on any building? That's not for me to decide, but that's a serious concern we have. We can't get into our neighborhood. That's a problem for emergency services, for people who have elderly, sick people with children. You have to be able to get in and out of the neighborhood. It is a very small and tight neighborhood with narrow roads and limited sight lines going around that corner. Like I said, there are older people, some medical conditions, many and a growing number of children in that neighborhood. There are no sidewalks, so those narrow roads become meaningful when there's no sidewalk either, right? Our concern is
That impacts everyone who lives in that neighborhood, right?
Right,
Yes.
yeah. And our concern is that to add to that, for example, a likely roadside driveway, a lot more impervious surface on that lot. Our concerns are what that will do to our ability to get in and out of our own neighborhood. On the short term, also just the construction itself would probably quite literally block access for a period of time, although I understand that, if you hold your breath long enough, that will pass and it will just be a residence and that won't be there anymore. But it's meaningful, again, because during a period of the year, Longfellow Street becomes impassable. Despite proactive and early and frequent treatment by the town with salt and sand, it still can be impossible to get up sometimes. In addition to all those, sorry, I'll refer to my own notes. I think that my understanding of the AHA is that, it doesn't supersede other zoning bylaw requirements. It does basically supersede the square footage and frontage requirements, but not the others. And for that reason, while council's made a very compelling point about those 2 points, I'm concerned about whether any ensuing property could still meet the conditions and be on that lot, whether it's setback, lot coverage, or what have you. And then whether the permit should continue to be denied. And then if approved, I would encourage the board to consider what the right conditions are so the rest of us can pass safely, continue to enjoy the neighborhood, and so forth.
Okay,
That's it.
thank you.
Speak a second time, I forgot something.
There's somebody in the front here. We'll let somebody new speak first.
Thank you for giving me the opportunity. My wife and I have lived for 42...
Could you give us your name
I'm
and your
sorry.
address, please?
Mike Matvachuk, 82 Green Street, which
Thank
is
you.
the corner of Green and Burns.
Okay,
One lot removed from 2 Burns Street and 2
Okay.
lots away from the 8 Fairview in question. As I said, we've lived there for 42 years. Our property is 1 lot removed from the one in question. And for what it's worth, I've been a town meeting member for the last 28 years, so I would like to include in my viewpoint this evening that of the homeowners at number 2 Burns Street who had a death in their family this weekend and couldn't attend the meeting this evening. In our time in our home, there have been 4 owners at the home property at number 9 Fairview across the street. The first 3 of those also own the lot at 8 Fairview Street. Each of these owners has been aware that the lot across the street from them at number 8 was an auxiliary piece of property that they used to, and that was unbuildable, that was used for various purposes.
Yes.
Things like a playground for the children, gardening space, a place to park their vehicles, because the driveway at number 9 Fairview only accommodates one car. And I don't know any family that has one car. So it's been strictly an auxiliary piece of property. They all recognized that it was unbuildable and accepted that fact. Back in the 60s, as we've learned, that property was conveyed to the owner at number 9, who used it for those purposes, and subsequently the other 3 owners. And now, the other 3 owners, I'm talking 41 of my 42 years, 3 owners own that lot at number 8 Fairview, and all used it for the same purpose, and all recognized that it was unbuildable.
Okay.
When each of those 3 owners sold the property, the home at number 9 Fairview, they also included the 8 Fairview lot in that transaction. For whatever reason, the last owner to sell that decided to not include that, or to retain the lot at number 8, not included in the transaction. It seemed a little perplexing at the time why that was the case, but I think we all recognize now that it's much more apparent why that happened. We all understand, I'm not telling you anything you don't know, that building a house in an R3 lot in Danvers requires 30,000 feet minimum. That lot contains 1/3 of that space, and it seems clear that the last seller of the house at 9 Fairview perhaps, and I'll emphasize the word perhaps, did not, perhaps misrepresented the possible use of that lot at 8 Fairview. While it's extremely unfortunate to the buyer, the neighborhood should not be required to pay the price of sidestepping the zoning requirements. It seems to me that the intentions of the last seller of the lot are the probable source of the issue here, and not the zoning issue, which very clearly states the requirements for building in an R3 lot. So I thank you for hearing me. On behalf of my wife and my neighbors at number 2 Burn Street, we respectfully request that you consider denying this variance. Thank you.
Thank you.
One other thought is addressed to Mr. Panos, Attorney Panos, is that you said it is a worthless lot. It is not a worthless lot. As Mike has said, there's been playgrounds. It is a place to park the cars and the neighbors when they've done it, and that's how it has been used. The neighbors at 2 Burns had expressed interest in putting their driveway there. They have to climb 2 flights of stairs, and they've both husband and wife have had several knee operations in the last few years carrying groceries.
So-
if they could have purchased, but at fair market value,
Yeah.
not what Mr. Dargan was looking for. So it does have value, and I had even, when I mentioned to Mr. Dargan, and he said he didn't give it to him, I said, you know, that's not a buildable lot, it was adjoined to mine. I even mentioned that, and I said, or mine, and I even checked with a lawyer that if I had bought it, I could actually put in a driveway and license the neighbors, and even give a license to the brand-new young couple that has nowhere to park their cars.
yeah.
It is a 14-foot wide
It's
road.
unfortunate if there was
So
a sign that
it-
no one in the neighborhood bought it, yeah.
Yes, it
Yeah.
wasn't presented, and no one knew that it went, except I saw him taking the sign
Yeah.
down, and
Yeah.
I knew.
Okay, thank you.
You're welcome.
Is there anyone else from the neighborhood that would like to speak? Do you want to make a comment?
Yeah, there were just a couple of things
Quickly.
I'd like to.
Okay.
Yes, given the late hour.
We have a lot of other cases tonight. too.
I know, I'm respectful of that. Quickly, accessory use is not a permitted principal use in R3, so
Yeah.
it is worthless. 2 could not have bought it for accessory purposes,
Okay.
number 1. Number 2, a lot has been made about the intent of the property as it relates to 9 Fairview. Well, if there was no merger with 6 and 2 Burns, 6 Fairview and 2 Burns, there definitely wasn't merger regardless
Across the
of the history across the street. There was a street dividing it.
Somebody just bought it, yeah.
Exactly. So I would leave that point there, but I stand by everything else I said in my presentation, regardless of the personal
Thank you.
attacks.
We may have
Thank
some
you.
comments for you or questions as we deliberate.
Thank you. Oh, I'm sorry, there's one thing I forgot. Pardon me. There was a letter that I neglected to transmit, and I just transmitted it to Brian. Now, it was a letter in support. Can I read it into the record?
Yes, go ahead.
Through you, the chair. It's from Justin Provencher of 13 Ipswich River Road, and he writes to the board
Which town?
here in Danvers.
Ipswich River Road in Danvers?
Yes. Ipswich River Road.
It's right on the line.
Okay,
He's, I believe he's on the abutters list.
okay, go ahead.
Dear Ms. Manson and the honorable members of the Zoning Board of Appeals, I reside in the neighborhood where the premises of 8 Fairview Street, Danvers, Mass. Is located, and I am familiar with the appeal application before the Zoning Board of Appeals by Christopher Iacoviello, pardon me, Chris, and Andrew Rowe for 8 Fairview Street LLC. I support their appeal to overturn the Danvers Building Commissioner's denial of the applicant's building permit application to construct a single-family home there with the current setback dimensional requirements of the zoning bylaws up to the size of the house proposed in the application, or in the alternative, grant a variance allowing the proposed development on the property, providing 10,000 square feet where 30,000 square feet are required, meeting all other dimensional and setback requirements of the zoning bylaws. Thank you for your consideration of our support.
Okay, thank you. All right,
Thank you.
where
I
else?
can promise to be very brief, and it relates to the letter he read in.
All right,
I had no interest in talking long.
go ahead.
I appreciate the prerogative of the parties to tour the neighborhood, meet people, solicit support. They came by all of us, right? They came by my home as well and asked for our support. I'll take the letter that was read in on face value. It's worth mentioning when visiting our home, the two gentlemen here misrepresented themselves, I think, very unfairly by saying we are not developers. We're just two people. Where we then, I was not present, but my wife was. Her response was, well, hold on a second, we've done our homework too. You know our name before coming over, we looked you up as well. You have LLCs for construction companies. Those construction companies have Facebook and Instagram accounts going back years showing net new properties and additions and renovations you've done. You are developers, right? And they sort of laughed. And she said, well, is the home for you or for you to sell to
Well,
other people?
I think this is kind of irrelevant to
Okay.
I mean, unfortunately, they are the owners of the property. I don't want you to.
Yeah, I will end by
disparage
saying I don't think
them.
that there's any law against lying, right? You could say you're from the planet Mars, and I don't think there's anything against that. I just know that they didn't earn our support in the form of a letter through that kind of presentation.
Okay, thank you.
Thank you.
Okay, we are now going to deliberate, and we'll consider all the comments and the presentation. Thank you. And I'm going to start with Kevin. No?
Could we ask just one more question?
Go ahead.
I'm still want to talk about these merge. Yes, please. Could I just sort of just discuss this real quick with
Yes.
all this? Because it's a lot of back and forth of different dates and
Sure.
if something was merged and if it wasn't or whatever.
Sure.
So pretty much, all right, Attorney Murphy says parcel 1, which is 9, parcel 2, which is 8, they were never contiguous and therefore never merged
Yes.
because they were separated by Fairview. Then you have, so you have what, lot 6 and 8 were merged in some way? Wait, so,
Yes, that's what I spoke about, 1920.
so 6 and, they were held, All right, so in 1946, it appears they were, but then the square footage changed to 30,000 square feet, and then it was sold. 8 Fairview was sold after. So then the Affordable Homes Act wouldn't apply then.
No, it would apply.
2024.
Because it's designed to prevent the very kind of merger that you're alleging. But I am arguing that, yes, according to 40A Section 6, Paragraph 4, merger precludes construction on property for single and two-family purposes. According to that, unless there is an overriding local town bylaw that grants more generous allowance. And there is, and I cited it to you, it's in Section 3, Paragraph 4. And it's entitled, and I go into great detail in my letter from yesterday. It's entitled Lawfully Created Situations, which, again, I'm going to reiterate, and I'm sorry to repeat myself through the chair, your bylaw does not have built into it the concept of merger. It just doesn't. You can't even find the word. Unlike 40A Section 6, which clearly says merger, stop action. You've got merger. No, your bylaw says a lot or any activity is considered to be lawfully created with respect to zoning requirements if it was in existence prior to June 19th, 1946, when the zoning bylaw was originally adopted. These were done in 1897. So they were lawfully created well before zoning came into play in compliance with that provision of your own zoning bylaw. And then there's a zoning bylaw provision that follows a couple of pages below that addresses nonconforming lots. And I give that to you. It's a somewhat lengthy provision, but the nonconforming lots provision in the bylaw contemplates that someone did something to that 1897 plan to change it, to supersede it, to make it obsolete. None of that ever happened. To reconfigure the lots. As I indicated, and I repeated this time and again, the lots created in 1897, that 1897 plan is the operative plan today. It hasn't changed. If Ms. Smith wants to sell her property tomorrow, she's going to refer to that 1897 plan to describe her property. It hasn't changed. There's no new plan of record. So your bylaw precludes this construct of merger. Now, in addition to that, you have the Affordable Homes Act. And the Affordable Homes Act definitively operates to say you don't have merger if you have a 10,000 square foot lot with 75 feet of frontage. That your lot, adjacent lots under common ownership shall not be treated as a single lot for local zoning purposes. It says it black and white. So you don't have merger. If you don't think that the bylaw says what I think it says, you've got the Affordable Homes Act that says exactly that, and it has some strings attached. But the determinative time to measure, and I can't stress this point enough, according to the Affordable Homes Act, is the time that the plan was recorded. What was the status of zoning at the time the plan was recorded in 1897? You didn't have zoning in 1897, so by definition it was compliant with zoning in 1897. Stop action. go forward. You have a 10,000 square foot lot that has at least 75 feet of frontage, located in a zoning district that allows for single-family housing. We meet the letter and spirit of that provision.
Yeah, but wasn't it
So no
changed at
merger.
30?
I'm sorry?
Yeah, but wasn't it changed from, to 30,000 square feet?
No, this is the brand-new Affordable Homes Act that the
Okay.
state, the Massachusetts passed in
Right.
2024. It's a brand-new law.
So it's designed to prevent the kind
It's
of
for the
merger
whole
that we're
state,
talking about.
So that we get more housing.
Now, it's worth mentioning, too, this is an opportunity, and I think this is important. This is
Okay,
an
we're
oppor-
gonna, okay.
Yeah, just very
Finish,
quickly.
Summarize.
Yes, this is an opportunity to kind of hedge your bets, because there's a provision on the ballot in November that's going to allow, if it's passed, by right building on 5,000 square feet.
Okay,
So what do you get? You get 2 houses on this corner lot.
thank you. All right. No. Mr. Sakali, is there anything that you would like to say? I'll just give you an opportunity.
Thank you.
You're in the middle of all this.
I definitely am in the middle of all this. There's a lot that has been said, and I'm not going to be able to summarize or point or counterpoint all the things that were said this evening. What I can say is that up until last night at 8:42, when we got this, we had never gotten the full title search.
The full.
The full title search, which
Okay.
is not the town's responsibility. Some people think that the town is supposed to do this deed research. That is not true at all. What we ask for is proof. Show us the research. Show us the deed research, and then we will analyze it. At the time, from what we had, we said, yeah, based on this, the question that was asked of staff was 8 and 9 ever merged? And the answer is obviously no, because there's a road in between. There's always been a road in between. So we said, yeah, those lots never merged.
Okay.
But the question at hand was that what should have been at hand was, have any of these lots ever been merged in the past? But what I'm trying to say is that we have not reviewed this brand new information as of last night. I sent it to legal counsel first thing this morning. I would have loved if they would have been here. They were unable to come this evening, but to at least analyze the deed research, because if 48 Section 6 applies, there's no need for any of this. There's no need for any of this. It either applies and they can build their house, or it doesn't apply and they can apply for a variance. That's essentially where they are.
Okay.
So if they're claiming that 48 Section 6 applies, they're in the wrong house. They can just go down to the building department, they can talk to us, they can prove it. And essentially, that's what they've done now. I'm not saying that they proved it, but they're trying to prove it through deed research. I can take this research to legal counsel, and then they can make a call, meaning make a determination based upon what they have provided. If that's the case, it's not in front of the ZBA. If 48 Section 6 applies, they can go build their house at 1,850 square feet, because everything else, it's totally true. Everything else is there. Setbacks are there. They got the 75 feet of frontage. They actually have 200 because you count both. They have everything they need according to it, except for this merger doctrine, like proof, essentially, or really anti-proof, if you really want to get into it. You have to prove that it didn't
Can I
happen.
ask Mr. Sakili a question?
Sure.
So, Brian, I guess where we are now, the board can overturn the decision, but I think what you're holding out is that staff can overturn its own decision or reverse its own decision on its own without
Oh, with
the
new
board's
information, yes.
Yeah.
I'm not saying that with this new information, we will overturn
No,
it.
it can, not
But
will,
it's
but
totally
can.
possible that with this new information, we can say this lot is buildable without you.
Right,
Yes,
under the new law.
correct.
Why do I have a feeling we're going to be hearing the appeal in another month anyway, if you do that, but just from someone else?
I mean, that might not be, the only thing that we can do is search for the truth and present it.
Okay. You want to go forward?
with debate? Yeah, I mean, I think it's worth,
I mean, unless you want to continue and get a legal opinion from town council.
Look, I'm not sure I entirely agree with Mr. Zakelli's assessment in the sense that we still have a denial of a building permit out there.
Okay.
And it's based on this lot merger. But I do agree to the point that if you overturn that denial, then what happens as far as the application of 48 Section 6, and we talked about this a little bit, is between the applicant, perhaps you, Brian,
Right.
and the building commissioner in coming up with a house plan that meets the 1,850 square feet heated livable. However, if what I was hearing was you'd like a little more input from town council on its application, perhaps? Because I really don't think merger applies here. I think it's a misnomer in this.
Okay,
and
but the question
yeah.
in front of you.
Do I want to
right now,
continue?
I mean, we can deliberate and we can give you our opinion, and then you can decide, but
Yeah,
I'm
why don't we-
asking you if you would like a continuance for an opinion from town council.
I'd definitely like to hear from the board.
Time out.
Yeah.
He cannot request that. The ZBA can request something from town council.
Right.
An applicant cannot say, I want town council to review this.
Yeah.
Right.
So the
Right.
ZBA has to say, we would like town council to review this.
but we could deliberate and inform the applicant where we are, and then he could.
That is your-
just decide
yes.
to request a continuance if he
That
wants
is,
to.
yes.
Okay. Can we,
Okay, so we're going to deliberate.
okay.
Okay,
Thank you.
perfect, thank you.
I guess I'll,
So we have two issues, right?
yeah, I'll start with the appeal. Do you want to start with the appeal and then move on to the variance, or do you
Yes.
want us all to state our opinion on?
Why
both?
don't you do both?
Okay. So I think this, first of all, is one of the, well, not one of the, this is by far the most complicated case in my, brief time on the ZBA. Lots of procedural issues, legal issues, like it's exceptionally complex. The procedural issues aren't compelling to me. I think that if we went down the path of calling what I still believe are, kind of advisory opinions, like I think every resident needs the ability to go to town staff and say, what if?
Yep.
Given this, what if? And I think that town staff is generally pretty careful about saying, but you should consult counsel, or given the set of facts you've given me, this. So that one's not convincing to me. The issue about the lawfully created situations in our bylaw, not addressing merger, I am not an attorney, and I'm always up here with learned attorneys making arguments that I am perhaps not qualified to fully parse. But I think, to my limited knowledge, that is kind of the nature of common law, is that we shouldn't expect to find it written. So I also don't find that incredibly compelling. Like, ultimately where I get to is the AHA or AAHA. Like, that's the one where I go, aha. You know what I mean? Like, I think that's the one, right? Because I think, like, the state, and as much as I wish it wouldn't happen, the state has taken
Yes.
some flexibility away from cities and towns and said this, like, we don't care what your bylaw says, this is the statute, this controls. So, like, I find that argument pretty compelling, but I am loath to just vote to overturn, because if we vote to overturn, we get exactly what they proposed, right? Without the, because we're not overturning for a reason, we're just overturning, right? And I, to my knowledge, and I'm happy to be corrected on this, we can't condition an overturning, right? It's not like a variance where we can list conditions. So, like, my preferred outcome here would probably be to continue if the applicant were willing to work with staff to see, one, if staff would agree that they're allowed to build a house on that lot, given the new information, the new arguments that have been presented. And two, so the analysis can be done of the, heated and cooled square feet, and the building inspector is certainly much more qualified to talk about exactly what qualifies there, a exterior wall, a bulkhead, whatever, right? Three-season porch. So I think that's where I land. I also think that this offers the neighbors some protection because they are limited to a modest-sized house on this lot, which I hear the concerns, I understand them, and I do believe people when they say that our understanding for 40 years was that this lot wasn't buildable.
Right.
And I agree with them. I think until 2024, this lot was not buildable. But unfortunately, the state legislature changed that. Fortunately or unfortunately, right? The state legislature changed that. And so I try very hard to come up with a decision that I think is based on the bylaw or based on the statute, and not just like what I would like to see. And I think that that's where I land with this one. That I think the applicant should be able to build a house, but I think if they went back to town staff, they could perhaps work that out. The variance. We have to meet all the specific conditions in 40A to grant a variance, as the board knows. Soil shape, topography, the topographic argument I don't really buy. I do agree that the land has a slope to it, but I don't believe it's the slope that is causing the lot to be undersized. So for that reason, I can't meet one of the required elements for a variance, so I wouldn't support a variance in this case.
Thank you.
Thanks.
Okay. Are you ready?
So I too wouldn't support the variance based on, I don't think it reaches the threshold of all the necessary prongs for that. And I believe it's more like a financial issue, and that doesn't reach the threshold of granting a variance to me. So I just, I would not support that. As far as overturning the decision on the town's decision to stating that it's not buildable, I wouldn't do that either. I don't think there's enough information. Really, I still am, this is ambiguous to me in some ways. I mean, there's a lot going on here, and I do not have a definitive grasp on what exactly is going on here. I think it's great that legal counsel for the town can look at this and sort of decipher it further. But as right now, I am not in support of overturning the building inspector's decision.
Thank you. Chris?
I think I'll echo what Ken said. In far as the variance, I don't see the financial part of it being the argument. That way I would not be in favor of the variance. And the building commissioner's ruling, I would also not vote in favor of that, but I'd also like to hear some feedback from town council. I didn't know that was an option in the beginning of this. Will it change my view? I'm not sure, but I still would like to hear a little bit more from them in regards to this. I'm also stuck on the closing attorneys. Like, it's $350,000 for a lot. What did they think was going to be done with this? Someone's not buying it to park a car there. From the beginning, there was going to be a house put there, no matter what. I think I'd be in favor of a house being put there, as long as it's not, what was it, 2,500 square feet? That doesn't belong in that neighborhood. Build a house, build a campanelli, build a ranch that looks like the rest of the neighborhood. This is more of a feedback, or not feedback, this is more of just me speaking out loud. That neighborhood, in driving a GMC 3500 down that street, I barely fit down that street.
Correct.
If I put an 8.5-foot plow on that truck,
School buses.
I don't fit down that street. How are you going to put an excavator? How are you going to put cement trucks? How are you going to put a pump truck for the foundation?
For the folks that are going to live there.
Please.
That's all I have. Thank you.
Facts. Thank you.
Okay, so I went through all of the correspondence. I think this is difficult. It's kind of a gray area, a lot of this, and I agree that this is very difficult and a lot of material to review. In February of 2025, Mr. Segelli said that the lot was buildable and issued an email in response to a request wanting to know if it was buildable. And also the assistant, Brian Cassidy, issued something saying that it was buildable. And in November 2025, Patrick Murphy, buildable. And then in November 2025, the owners, the buyers, they closed on this property for $325. I personally, in town, have owned 2 properties that were pre-existing non-conforming uses. And I relied on the building department and the planning department for information as to whether or not I could proceed and do what I wanted to do. Mr. Segelli is the zoning enforcement officer. The building inspector is not the zoning enforcement officer. Mr. Segelli made the decision that this was a buildable lot, and I feel that the buyers relied on that, and not to take anything away from him, but he made the decision, he put it in writing to the buyers, and they proceeded and purchased the property. Can we then, 3 months later, go back and say, well, we're sorry, we made a mistake, and we're sorry you paid $325,000, and your money is gone, and now you can't build? I don't think we can do that as a town. I don't think it's fair. When we go to the building inspector's department, or we go to the planning department, it used to be the building inspector made the decision. That was changed, and now the planning department makes the decision of whether something complies with zoning. And if we go to them, we need to be able to, they put it in writing, we have to be able to rely on it. So from my perspective, I feel that the building inspector didn't have the authority to say it was not buildable after the planning department said it was buildable. I think the Affordable Homes Act is the way to go. I really think that we didn't like ADUs either, and now everybody can build a house in their backyard, and that's what the state decided, that we don't have enough housing, so we can build, everybody can build a house in their backyard. Do we want this in our town? No. Do I want it in my neighborhood? No. And I totally understand you, but now we've not only gone from the ADU, accessory dwelling unit, to an Affordable Homes Act. And who knows where else we're going, because we don't have enough housing in the state. So my feeling is that if, that we should get an opinion from the town council and see if, I would rather see them do the 1,850 square foot house.
So is the direct question then whether 48 Section 6 applies and whether council believes that to be the case?
Yes,
Okay.
yes. Because I don't think we can take away a property that somebody already purchased and make it unbuildable. I just don't feel it's fair. So I guess I'll poll the board and see what you think.
So, yeah, I guess at this point, I think I've heard from you, and I think I got the sense from Chris, at least, that he'd like more information. I'm not sure about Ken, I'll let you speak for yourself here in a second. I think what I would probably be most in favor of is a continuance to allow us to get an opinion from town council about the new aspect of 40A and whether this applies. And also in that time, there may be discussion between staff and the applicant, pending the outcome of town council's opinion on that.
Yeah.
I think that's where I would go, is to do a continuance.
I think that, the state is shoving stuff down our throats, and we're going to end up, having to accept some of these things. So I'll let you say if you're okay with that.
Yeah,
Okay.
the
And what do you,
continuance
Chris?
sounds
Okay with that as well.
Okay,
Yep.
okay. All right.
We'll agree with a continuance through July 27th.
27.
Okay. And that'll give us enough time, right?
That should definitely give us enough time.
Okay.
And I'll encourage that internal discussion.
And I don't know if I said, but I would not be in favor of the variance either, so,
Okay,
Yeah.
you did not.
no,
but
okay.
We require
can I
a
have a motion?
unanimous vote. I know
Madam
that.
Chair, I make a motion that we continue this matter until July the 27th.
In
I
second,
second.
all in favor?
Aye.
Aye. Opposed? Thank you. Thank you, everyone.
Thank you very much.
All right. Do you want to take literally a 2-minute recess just to clear everybody out and change
Yeah,
around?
We're going to take a 5-minute break here. You're welcome.
Tonight.
You're next, Bill.
Mine was hurting out there.
Just let me read it in.
I typically don't unless I'm, yeah.
Ready to go?
Yes.
Yep.
All right, you're good to go.
Folks, we're going to come back into session now, and before we move on, thank you that's quite a complicated case, and thank you for the other folks that are here for hanging in with us. We'll try to move judiciously along here to not tie up further on your evening. And with that said, Mr. Clerk, our next case, please.
Thank you, Mr. Chairman. Our next case is 34 Endicott Street. This is zone Danvers Port Industrial. Request a finding under Section 3.11 of the Danvers zoning bylaw to construct an accessory building that will be located closer to the front property lines, Endicott Street, 6.9 feet, and Appleton Street, 7.1 feet. Then permitted as of right, which is 50 feet. The request is made by Keith Oakley, docket 26-5140.
And who's here on behalf of the applicant?
Good evening, Mr. Chair. My name is Bill Nolan from Savoy Nolan Architects. I'm the architect here representing the owner who is with us tonight as well, Keith Oakley, Patriot Fence Crafters. So I'll be brief. At our last meeting, we presented essentially what's in front of you on the screen, a detached structure. Seemed like we were going to get the votes for it, and kind of at the last minute, there was a question as to whether a detached structure constitutes an extension of an existing nonconformity. We continued. Brian Zacchelli got back to me very quickly. Thank you for that, Brian. And determined that the town now looked at detached structures as not being an extension of an existing nonconformity. So our approach is to actually connect the buildings. You can see a small little square there. There's an existing door on the existing building at that location. And it's actually a happy accident because now it provides an interior connection, especially at like a day like today. They can go from the offices, which is in that existing building, to the new structure that we're proposing. In all other respects, it's the same as last time we presented, so I'll spare you the details unless you have any questions.
No, I think that kind of hits the nail on the head. I've got a couple of questions myself, but I'm going to turn it over to the board. Do you have anything else you want to present?
I'm happy to answer questions.
Corinne, we'll start with you.
I have no questions, thank you.
Ken?
No questions, thank you.
Ken J?
No questions? Thanks.
Chris?
No questions, thank you.
I have two. Two of the things that came up at the initial meeting, because I reviewed the tape, was illegal signage at the property. Could you speak to that, and have they been removed?
Sure. I don't know if they've been removed. I did speak with the owner. We can ask him in a second. I did speak with the owner. He's aware of it, and the signs will be taken down.
Okay.
Yep, if they haven't already, have they?
If I could have the owner identify himself and speak to that.
Hi, Keith Oakley, owner of Patriot Fence. They're just zip tied up now, so we're very quick, so we can take them down, immediately, so. It's just,
Okay.
they're just a couple of banners that are attached to the fence, so it's not any type of permanent signage.
Okay, I think 3 banners, right? 3 large ones, right?
Yeah.
Yeah.
Also, there's a couple that are for the anniversary of the country. Would those come down too, or is that that's like a
I'll
separate
go out
thing?
to our planning director on that.
So yeah, the messaging doesn't actually matter. So it doesn't matter what's on the sign. It's
Yeah, it's the
Okay.
sign itself, so
That's
yeah,
fine.
all of
I
it.
wasn't aware of that, but okay, yeah, we can pop them.
That's why we do this.
Yeah.
Get everybody on the same page. And might as well stay up there. The other thing was, there was there are, I guess, quantify for me right now how many storage containers are on site. And you do realize that those are only permitted for 180 days.
Yes, I wasn't aware of that, but yes, there's 3, and that was part of the plan, is to remove those.
And so the plan, would you take in condition to make sure those are removed prior to construction?
Yes, yeah.
Prior, or are they needed for during?
Do we need
Yeah.
it? Yeah.
Hold on for 1 sec. Yeah, just give me 1 sec. So part of the reason why we're doing this addition is so they can keep his business operational. We're going to be effectively removing an existing contractor yard during the construction of this, so we're limiting his property So what we were hoping to do is go through the town, apply for the proper permits for those. I know they're temporary, to give us some reprieve until the building is built. At this point, just to build that building, he's going to have to resurface.
Understood. So within completion, these would be removed?
Yeah.
That's all I wanted to hear.
If we could amend the condition to state that as opposed to prior to.
Well,
Yes.
I think probably like prior to CO is probably
Yeah,
would
prior
be-
to CO works
be
for me.
realistic conditions for prior to the CO for the. new
Prior to
building.
occupancy, the storage would be gone.
Yeah.
Okay,
That's reasonable.
excellent.
Yep, thank you.
I will go out to the public who are here on 34 Endicott Street, Patriot sign. Anybody want to be heard or say any words of wisdom? Very good. Hearing none, I'll come back and we'll deliberate. Corinne?
I would vote for this with 3 conditions. One, that the 3 illegal banners or signage must be removed, that prior to the certificate of occupancy being issued,
Storage.
that all the storage containers will be eliminated. And with regard to the storage containers, if it's pursuant to construction, do they have longer to keep them there or not?
So if it is
It-
part of,
wait a
it,
minute.
right, if it's part of a building permit, but,
Okay.
but at the moment, it's not. So that's
Right.
why I think you should put it
Illegally
as a
right now,
condition.
yeah.
No, no, I am
But
leaving
yes,
it as a
you are
condition.
correct. Yes.
Okay. And the only reason why I'm saying that is the owner, I believe, said he was going to go to, down to Town Hall, but if it's over 180 days, he's not going to be able to get that. So that's why I'm asking if they pull a permit and have those storage containers as part of the construction process, did they allow them to have it through the end of construction, or are these containers not even part of that because they're not considered temporary for construction?
I mean, if they're actually part of the construction,
Yeah.
then they're associated with a building permit. I would
Okay.
say that they're not associated with the building permit because they're storing material now.
True, true.
So I would,
Okay.
I wouldn't say the storage containers are there for the construction of this
the
proposed
purpose of
building.
this.
So
Okay.
the idea is that I would put it as a condition for it to be removed.
Oh, no,
prior to
I
CO.
definitely want that. I agree. Okay, thank you.
Thank you, Corinne. Ken?
Yeah, I will vote for this with those conditions.
Thank you, Ken. Ken J?
I'll vote for this. Yeah, I'm not too worried about the signs, but they are in, I guess, violation. So they look pretty cool, though. It was the 250th anniversary, you know, I mean, they'll probably be off like after that, right, in July. So,
Like
I mean,
8
we
days?
could give it a couple more.
Another condition after the 4th?
Yeah, after the 4th, baby.
I
That's
shouldn't
what
have
I'm
said
for.
that. Just kidding.
Chris?
I would vote in favor for this with the conditions set forth.
Thank you, Chris. And I too would vote for this. I think we came to the right conclusion here with the proper relief sought, and by adding this vestibule, sounds like it's going to help your applicant as well. So with that said, could I get a motion, please?
I make a motion with regard to 34 Endicott Street. I make a motion to grant a finding under Section 3-11 to the Danvers zoning bylaw to construct an accessory building that will be located closer to the front property lines, Endicott Street, 6.9 feet, and Appleton Street, 7.1 feet, then permitted as of right, 50 feet, and that the proposed extension, alteration of the structure is not substantially more detrimental than the existing structure to the neighborhood, and with the following conditions, that the 3 illegal signs on the property be removed immediately, and that prior to the certificate of occupancy being issued, that all storage containers be removed from the property.
I've got a motion. Could I get a second?
I'll second.
Any further discussion? Hearing none, all in favor?
Aye.
Opposed? Good luck.
Thank you.
You got it.
Good night.
Mr. Clerk, moving along.
Our first regular item is 9 Grove Street. This is zoned R2. requests a finding under Table 2, Table of Dimensional Requirements, to permit a second-story addition that will encroach into the side setback at 13.7 feet, where 15 feet is required. Request is made by Kyle and Alex Gable, docket 26-5141.
Hi, who's here on behalf of this application?
My name is John Andrews. I'm the project manager from JFA Design Group.
Welcome.
Mr. Gable is here as well. So,
Tell us what you'd like to do.
all right, so we got a single-family ranch home over here on Grove Street, and it has 3 small bedrooms in there now. What we'd like to do is put a second story above this, so it sticks, well, it's a little bit beyond the existing footprint, but it's not any kind of foundation. So as the second story comes up, we have a 2-foot overhang in the front and the back of the building, and then we have a 1-foot overhang on the left and the right side. I guess from the setback in question is if you're looking at the front of the house, it would be on the right side from Grove Street. And that overhangs 1 foot. So we didn't have the 15 feet originally on the existing house to begin with, and we're asking for relief there.
Sounds like your shortest point is 13.7 according to the plan?
Yes, sir. We have a growing family, so we're going to add 4 bedrooms. And just, now Mr. Gable told me today that they have 3 now and 1 is on the way.
Well, congratulations.
There it is.
And,
It meets all the other requirements as far as height requirement and all that other stuff. So we're not going to, like I said, put a foundation there. We're just going to build above. We do have structural engineer involved with it.
Yep.
And he's already stamped his plans.
Well, very familiar with these types of houses, and I did take a ride out to the property and have a look. It's currently empty?
Yes.
Yep.
Mr. Gable moved out.
Okay, I will, if you don't have anything else to present, I will turn it over for some questions.
Very good. Thank you.
Okay, Chris, down there to you.
Oh, hold on, I already went past it. The existing garage,
Yep.
that gonna become livable space?
No, there's already livable space in the garage. It's kind of a strange layout. So there is a small area that's there. So we're not going to expand on that at all. We're not going to expand onto the garage as well. We're going to keep that interior space. We are going to do some renovation to it as far as taking off sheet rock, that kind of thing. You know what I mean? And cleaning it up and flooring. Yeah, but that space is already in there. So if you look sort of, you can see, I guess the best one is the existing demolition plan, EX1. It shows a garage entrance in the garage, and then it shows a door going into, and that was living space prior to that. So it was really just a 1-car garage.
Okay, thank you. No
I
more
guess it's
questions.
the, I'm not familiar with them. I guess it's Campanelli home, everybody.
We're
the
very
area knows
familiar with
about
them
it.
up
Oh,
here.
all right.
Yeah.
Okay.
That whole neighborhood. Ken J., questions?
I have no questions. Thank you.
Thank you. Mr. Scholes.
I don't think I have anything. I get what they're trying to do.
Karine.
What is the plan for parking cars then, if there's no garage, if it's all livable space inside?
Yeah, so the driveway is generous, enough to hold 4 cars there, but the parking, 1-car parking will still remain.
Okay.
Yep.
Okay, thank you.
Sure.
Thank you, Karine. And this might be more for Brian, and maybe I'll start with you. The shed to me looks like it's oversized, does not fit our 120 square foot. Do you know if a permit has been pulled on that, and when did the applicant buy this property?
Okay. When you bought the property? 2019. Was the shed put in by you? Okay, so the shed was existing.
Shed was existing when the property was purchased?
Purchased, yes.
And Brian, I guess, do we know if a permit was pulled on the shed?
I can take a look, but I don't know now.
Okay. Do we know if it's oversized? Our bylaw allows for a 10 by 12.
10 by 12?
Yeah.
I don't know the size of that, I gotta be honest with you. I can put that in as a condition and find out what it is, and then what happens if it's over that?
If it's over there, it
Or
would...
you would have to go and
It
get it
matters when it was
re-permitted?
built. No, it matters when it was put in.
Installed,
Yeah,
yeah.
it matters
Oh,
when it was
I
put in.
see.
So if it's prior to them, if it's more than 10 years old, then it's pre-existing non-conforming, even if at the time. So we can do a little bit of that. I mean, I can do a little bit of research there, but that's kind of outside of this, but I can certainly follow up on that with the applicant.
I can have the surveyor do that measurement there and then also redo the proposed lot coverage, if that helps as a condition.
Yeah, I don't know if that's necessary. I think it's more of a, it's just something we check in on with
Oh, I see what you're
properties.
saying, right, as you're looking
If it's an oversized shed, it has to meet setback. If it's standard size, it doesn't.
I
And
gotcha.
Clearly, this one doesn't meet setback either.
No.
If it's 120 square feet, it doesn't have to. But if it's
see.
200 square feet,
It
it's
has to,
technically
yeah.
supposed to be at the same 15 feet. So I guess we'll leave that as TBD.
Okay.
How about that?
Listen here.
Okay, and I'll go out to the public on this. Anybody here to be heard on 9 Grove Street? Hearing none, I will come back, and Chris, we will deliberate on this.
I would be in favor for this. I love the fact that you want to stay in the neighborhood. Those Campanellis are not easy with a growing family. I know for a fact. Good luck, thank you.
You're in favor. Ken J.
I'll vote for this. I'm fine with it.
Thank you. Ken.
I will vote for this.
Corinne.
I will vote for this, too.
I too will vote, and I just will ask informally that we try to clarify the shed through the inspections department.
Sure.
With that said, board members, could I get a motion?
I make a motion with regard to 9 Grove Street to grant a finding under Table 2, Table of Dimensional Requirements, to permit a second-story addition that will encroach into the side setback at 13.7 feet where 15 is required, and that the proposed extension, alteration of the structure is not substantially more detrimental than the existing structure to the neighborhood.
I'll second.
I've got a motion and a second. Any further discussion? Hearing none, all in favor? Aye. Opposed? Congrats and good luck.
Thank
Good
you.
luck.
Oh, just one last question to the board is, we write the decision and it's a 20-day appeal period or a 30-day
Correct.
appeal?
20.
20.
And
So
you worked that out with the
Yep.
planning department?
It'll get
Yep.
written before
Thank
the
you.
end of the week, and we'll be in contact with you to let you know when exactly to pick it up.
Thank you. Okay. We're moving at lightning speed here. Guys got a full education on zoning tonight.
Merger.
We all did, I think.
Merger.
And merger. Don't say that word too much. Okay.
4-letter word.
Let's go on to our final case, Mr. Clerk.
Thank you, Mr. Chairman. Our last case is 187 Pine Street. This is zoned R1. Request for finding under Section 3 for a front setback encroachment of a proposed addition that will be located closer to Crestline Circle than allowed by right, 18.5 feet where 20 feet is required. The request is made by Brendan Delicio, docket 26-5143.
And who is here on behalf of the applicant?
Hi, it's the homeowner, 187 Pine Street, Brandon Delicio.
Welcome. Tell us what it is you'd like to do.
We're looking to add another bedroom on the second floor and expand the first floor. Basically, to make it in simple terms, is doing a 16 by 30 addition into the backyard, keeping the side of the house that is faces Crestline the same distance away as it is now, but we want to add the roof overhang. So doing a roof overhang, and we already kind of don't meet the setback that's required as it is.
This is
So-
why it's a finding.
And that is where we are here today.
Okay, and I have to, I visited your property yesterday. I have to say I admire the tree in your front yard, and I'm glad you're
Thanks.
going backwards. That's quite a tree, pretty fantastic tree.
Yep.
Okay, anything else you want to present?
I think that's it.
Okay, Kareem, we'll start down there with you.
I don't really have any questions. I do love the design, though.
Thank you.
Very nice. But I don't have any questions.
Thank you, Kareem. Ken?
I don't think I have any questions. The deck's fine. I don't have any questions.
Thanks. Ken J.
It's pretty cut and dry. I don't have any questions. Thank you.
Yeah, it's going to look nice.
Chris?
No questions, thank you.
Geez, you know, the more I think of this, I should have had these residential cases first and got you guys out of here tonight, but you had to suffer with all of us. That's the way I look at it. I do have a couple. Approximate square footage of the house currently.
Want to say it was, I started doing the building permit and I had that figured out.
Yep.
And then I going to get the plot plan updated with the drawing that we want. So I got, I want to say it was, I don't recall at the moment.
Okay,
Your question was our existing, it's like 1,200.
1,200 square feet, roughly 1,200, somewhere in there. And how much are you adding? What's the addition going to add?
16 by 30.
60 by 30? Oh, that,
16 by 30.
Okay.
Yeah, 2
And
stories.
so is there a deck out there currently, and you're just removing the deck and putting in a,
No.
or is there a first floor and you're just adding a second floor to the top?
We are basically we're coming out that 16 feet and the width of the house now, which is 30, and going up 2 stories.
Okay, so this will be a full foundation with a basement?
Yes.
Okay, so this is total new construction?
Totally new. The
Yep.
deck's new as well in the back.
Okay. So you're gonna encroach, and this is R2?
One.
R1.
This is R1.
No.
No.
Yeah, sorry.
Yeah, R1.
No, this is R1. It's 20 feet. They're at 18.5.
Right.
Yeah, because it's a front,
Those are the overhang,
it's two frontages, correct?
Correct.
Yep. Okay, that answers it for me, thank you. Anyone here on 187 Pine Street wishing to be heard, make a comment? Yes, sir.
And there's nobody online.
Thank you.
They're all in bed.
Everybody's home, sleeping.
Bill Bradstreet, town meeting member, precinct 1. I heard a comment about a very nice tree in the front yard.
There is, I noticed it.
Can you make a determination that the tree has to stay, or if something happened, it's replaced with a tree, not a twig like I've seen done?
Well,
I'm sure they want that tree there.
the good thing, Mr. Bradstreet, is that tree is in the front of the house.
No, I
and-
understand.
And not affected by this construction.
Okay, no.
But I'll make the applicant answer that, but, and that's it. Thank you, sir. Could you just speak to that? It sounds like the tree, in my estimation, will not be affected in any way by this construction.
The tree will not be removed or affected by the construction.
Very good. And any disturbance of existing trees on the property to do this?
That's, I think, as one of the few trees that I have, yeah.
Okay.
Yeah.
So you're good.
We're good.
Okay. And with that said, I'll come back to the board, and I started with you, Corinne, or did I start with Chris? I started with Chris.
I think you started with Chris.
Oh, you started green.
Oh, no. Did you start with me?
It's too late for me to know, so I'll leave you guys.
I'll go.
Go.
I will vote for this. I think the design is very nice. I do have to say, as much as I love the tree, I don't think we have any jurisdiction.
No, we don't.
With
But it's
regard
good
to
to
the
ask.
tree,
It's worth asking.
unfortunately. But yes, I will vote for this.
Thank you, Ken.
I will definitely vote for this.
And Ken J.
Yeah, I'll vote for this as well.
And Chris.
I will vote for this as well.
Yeah, and I think property looks nice now, and I'm sure it'll look better with this addition. And I too will vote for this. So if I could get a motion, please.
I make a motion with regard to 187 Pine Street to grant a finding under Section 3 for front setback encroachment of a proposed addition that will be located closer to Crestline Circle than allowed by right, 18.5, where 20 feet is required, and that the proposed extension alteration of the structure is not substantially more detrimental than the existing structure to the neighborhood.
I will second that.
I've got a motion and a second. Any further discussion? Hearing none. All in favor?
Aye.
Opposed? Good luck, and
Good luck.
Thank you.
Nice.
with that said, Brian, and unless you have any business, I will close the meeting.
No business.
Motion to adjourn by somebody?
Second.
Adjourn?
A second?
Second.
Second by Ken. All in favor?
Aye.
Good night, Dan.
Good night, Danvers.